Hello, my name is David Doorey. I'm a labor law professor at York University, and you might have heard that a strike by part-time instructors represented by CUPE 3093 has begun at York. And this is a lawful strike in the sense that CUPE has satisfied all of the legal requirements to conduct a legal strike. And by striking, obviously, CUPE hopes to build pressure on the university to improve its offer in collective bargaining. And to do this, the CUPE members need to inconvenience the employer, put as much pressure on the employer as possible. And so we can anticipate that they will cancel classes that the CUPE members teach, and that they will also probably set up picket lines around the various roads that lead in and out of the campus. And I've been around York for quite a while now, and I've been through several of these strikes. And as one of the labor law professors on campus, I am often asked about the rules of picketing. What can they do? What can they can't? What are they not allowed to do? And so I thought I'd put together a short video that explains the law of picketing in Ontario. And so I'm going to focus on the York situation, but I think what I have to say is sort of generally applicable to strikes and picketing any place. Okay, and so. A lot of what I'm going to cover, I go into much more detail in my book called The Law of Work. And in particular, this material focuses in on chapter 34 of the book, which is called The Law of Industrial Conflict. Okay. Now, I'm recording this video on the eve of the beginning of the newest 2024 CUPE strike. And so in terms of the facts, I'm basing a lot of what I'm about to say on previous strikes and what I anticipate will happen this time around. Okay, so we can anticipate that within days of the beginning of the strike, CUPE will set up picketing stations at various entry points around campus. And CUPE members will staff those picket lines. You'll see them out there with picket signs and flags and boxes of Tim Hortons coffee. We're getting warmer here, so we might not see fires burning, but we'll see a bunch of people there. And in the past, sometimes CUPE has also put up fences, barriers. And they will stop cars coming in and out, hold them there for a few minutes, talk to them about the strike and why they're on strike, and then after a period of time, they will move the fence out of the way, and one or more cars will pass, and then the fence will be closed, and we'll go through that process all over again. Okay, and so the question I'm often asked in the past about these strikes is, how is it that picketers are permitted to physically block roadways? In other words, hold people up from getting in and out of the campus. I'm asked, isn't this illegal? Why doesn't the university stop it? Why don't they call the police? And to answer these questions about why CUPE members are, I'm focusing on the CUPE York strike, but this is applicable to all strikes and all picketing, at least in Ontario, but most of what I have to say applies right across the country. Okay, so in order to understand why picketers are allowed to do this, we need to first understand the architecture of strike and picketing law in this country. And so in Ontario, we begin in labor relations matters by looking at the Labor Relations Act, which is the statute that governs the relationship between unionized workers and unions and employers, including collective bargaining and the law of strikes. And one thing that's interesting when you start with the Labor Relations Act is that the word picketing doesn't appear anywhere in the statute. Okay, if you do an e-search of the word picketing in the Labor Relations Act, you'll find nothing. What we learned from that is that the labor relations legislation that we usually look to for collective bargaining laws says very little about picketing. Okay, nothing specifically about picketing. There is a section that addresses picketing indirectly, and if you look at Section 83 of the Ontario Labor Relations Act, it essentially says that no one can do something that as a probable and reasonable consequence of which is to cause another person to engage in an unlawful strike. Okay. So this section could apply, for example, if CUPE workers attempted to block or persuade workers who are not in CUPE and who are not in a legal strike position, like me, for instance, to join them and engage in what we call a sympathy strike. Okay. However, if you look at Section 83.2, follows that, it says that the limitation in 83.1 does not apply when the picketers are engaged in a lawful strike. So in short, the Labor Relations Act takes mostly a hands-off approach to picketing related to lawful strikes and lockouts. Okay. Now, since the Labor Relations Act does not regulate picketer behavior during a lawful strike, do some other laws apply? And the answer is yes. Okay. In Ontario, there are 3 additional sources of law that we need to consider when we look at the laws of picketing. Okay, and they are, firstly, the common law of tort, the common law rules governing the granting of labor injunctions, which we'll discuss in a minute, and thirdly, a statute called the Courts of Justice Act. Let's start with a quick discussion of torts then. As I explain in Chapter 16 of the Law of Work, torts are legal rules that have been created by judges over time that regulate the conduct between 2 parties. Okay, so torts permit people or businesses to recover damages when they have been harmed by the actions of another, even if there's no contract between those parties and there's no statute that applies. Okay. Now, one additional benefit of torts for the alleged victim is that judges can sometimes order something called injunctions, which is basically an order that against the person engaging in the alleged unlawful tortious behavior to stop committing the tort. Okay. Now I'll come back to injunctions in a minute. Okay? They're very important in labor law and specifically in regards to strikes and picketing. Okay. Now, back in 2002, the Supreme Court of Canada ruled in a case called RWDSU versus Pepsi Cola Canada that picketing is a very important form of expression. And that therefore picketing should not be restrained too easily by courts, okay? And in fact, courts should not stop labor picketing, in particular, when the picketing is engaged in a manner that's lawful. Now, this is known as the wrongful action model, okay? So picketing in support of a legal strike is presumed to be lawful unless it can be demonstrated that the manner in which the picketing takes place is unlawful. Okay? So what does that mean in practice? Well, if the picketers are engaged in criminal behavior, for example, on the picket line, such as, say, physically assaulting or threatening people who cross the picket line, or destroying property, like smashing cars with bricks or sticks or something dramatic like that, then obviously that's criminal conduct, and we would expect the police to intervene and arrest people. Okay? Lawful picketers do not have a license to commit criminal acts. Okay? Now, thankfully, criminal behavior on picket lines is relatively uncommon in Canada, although it has happened. And I should note that the risk of behavior of violence on picket lines goes up when employers use replacement workers to do the jobs of strikers. Nothing provokes people to violence like a full bus of replacement workers driving through the picket line to take the strikers' jobs. And this is actually one of the reasons that advocates of legislative bans on replacement workers argue that the law should step in. The argument is that the use of replacement workers increases the potential for picket line violence. Okay, but I don't anticipate York trying to use replacement workers to do the work of CUPE workers. Okay. More frequently than criminal behavior on picket lines, we do see torts being committed on picket lines. Okay, so we're mostly concerned with what we call tortious behavior on a picket line. Okay, now in my textbook, I summarized some of the most common torts that can be engaged or that can arise in regards to typical picketing situations. For example, if picketers place a physical barrier on a public road that blocks cars from entering or exiting a place that they otherwise have a right to go, then the picketers are probably committing a tort known as nuisance, okay, or obstruction. Okay. If the picketers set up on private property, then they may be committing a tort of trespass, or nowadays a statutory violation of trespass to property acts that we have in Canada. Okay. And if blocking access to a business were to cause third parties like suppliers or contractors that have contracts with the business that's being the target of the picketing, if it causes those contractors to violate a contract that they have with the business, then it's possible that a tort known as inducing breach of contract could arise. Okay, so there's a variety of torts that could arise in the situation of labor picketing. Okay, now as I mentioned earlier, in previous strikes at York, the CUPE picketers have, in fact, placed physical barriers on the roads in the form of fences that prevent the cars from going into the campus. Okay, and that conduct is probably almost certainly nuisance or some sort of unlawful obstruction. So then the next question is, why are the picketers permitted to do that? Right? Why don't the police stop it? Or why doesn't York run to the courts and get a judge to order the picketers to stop blocking the roads? And sometimes employers or businesses that are targets of picketing do that. Okay, and then the courts need to decide what to do. Okay, so here's what typically happens when an employer or a business attempts to put an end to labor picketing or some form of labor picketing. Right? So if the employer or someone affected by the picketing believes that the picketers are engaging in a tort, then they can file a lawsuit in the courts against the union leaders and the picketers. Okay? Now often the employer, let's say it's York University, may not know all of the picketers, right? They might know a few of them, they might know none of them by name. Okay, so in that case, they will name who they know, maybe name a union leader personally, and then they'll add something like or others presently unidentified, or persons who have knowledge of the order, or something to that effect. Okay, so the idea is the lawsuit is against all of the individual people who are engaged in the unlawful picketing, right? Because what you're ultimately trying to do is get the court to stop those people from breaking the law. Okay. Now, here's the thing. Because that lawsuit may take months or even longer, sometimes, it's possible it could take years before a trial is scheduled and actually litigated and the court actually writes its decision about whether a tort was committed, right? Because that process can take so long, the party complaining that the picketing is unlawful can apply to the court in the meantime and ask for something known as an interlocutory injunction. Okay? Now, an interlocutory injunction is a temporary order by the court that tells one of the parties to stop doing the act that the other party claims is unlawful until such time as the court can finally decide the lawsuit. Now, in practice, the labor dispute is usually long settled before a court will ever actually hear and decide the lawsuit about whether the picketing was a tort. Okay, so in practice, in labor disputes, the interlocutory injunction usually behaves as if it's a permanent injunction. In other words, if a court orders the picketers to stop engaging in what is alleged to be unlawful picketing on an interim basis, in other words, until the case is finally decided, in practice, that will usually mean that the workers are prevented from picketing in that manner for the rest of the labor dispute. Okay. Okay. So to summarize where we're at so far, in most cases where an employer challenges picketing, they will file a lawsuit with the court alleging that the picketers are engaged in an unlawful tort. And then they will immediately or simultaneously file an application to the court for an interlocutory injunction, asking the court to stop the alleged unlawful behavior until such time as a trial can be held to determine whether the picketing is unlawful. Okay, so far so good. Let's move on then. Now, what is the test for getting an interlocutory injunction? Well, there's two steps that the university would need to address. Okay. The first involves satisfying the requirements of a statute known as the Courts of Justice Act. Okay. Now, the Courts of Justice Act deals with a bunch of issues relating to courts and lawsuits, but for our purposes, the important part is that it creates conditions that must be satisfied before an injunction restricting picketing in a labor dispute can be issued. Okay. And these rules are designed to prevent employers from rushing to the courts and getting a fast order restricting picketing from a friendly judge, which used to happen a lot in the past. So there are now rules about giving the union fair notice of the application so that the union can appear and prepare a response. And there's also a rule requiring that no injunction can be granted in a labor picketing situation unless the employer has first called the police and the police have come and have been unsuccessful at preventing injury to people or property or ensuring the lawful entry or exit from the property. Okay. Now, in practice, in recent years, police in Ontario have generally refused to intervene in labor picketing if the picketing is peaceful, even if it involves obstruction of cars. Okay, police have tended to get involved only if there is criminal behavior, such as violence or threatening violence or destruction of property. Okay, but the courts have said that when the police have been called and have said that they will not intervene to stop the nuisance, for example, then that is enough to satisfy the Courts of Justice Act requirement that the police have been notified and have been unsuccessful in bringing an end to the picketing. Okay, so satisfying the Courts of Justice Act is the first requirement that the employer needs to satisfy in order to get an interlocutory injunction to stop what it alleges is tortious picketing. The next step for the employer is to satisfy the common law test for the granting of an interlocutory injunction. Now, that test was set out in a case from 1992 known as RJR McDonald, and so we call this the RJR McDonald test. And that test requires the employer or the party seeking to have the picketing restrained to satisfy 3 points. Okay, the first is that the first requirement is for the plaintiff to demonstrate that there is a serious issue to be tried. Okay, so in our case, York University would have to demonstrate to the court that there is a serious issue to be tried. And in practice, if the allegation is that the picketers are committing a tort such as nuisance by physically obstructing entry into the campus, and there's some evidence of that, the employer would put in some evidence through something called an affidavit, which is like a witness statement of what's happening. If the employer sets out and alleges with some evidence that a nuisance is being committed, then that first part of the test will usually be satisfied. Okay, if there's an allegation of a tort, then the court will probably say that's a serious issue to be tried, unless it looks like it's being completely made up and there's no evidence whatsoever to support it. Okay, so usually we would expect the employer to satisfy this first test. The second test in the RJR McDonald test is that the plaintiff, or in our case the university, needs to show that if the injunction is not granted, that the employer will suffer something known as irreparable harm. Okay. Now, irreparable harm means basically that the harm that will be incurred if the picketing is not restrained cannot be compensated later by simply ordering the picketers or the union to provide money, right? So it's the sort of harm that can't simply be resolved by, ordering damages later, okay? Now, some of you might remember last summer that there was a strike at Metro stores in the Greater Toronto area. And at one point, the picketers showed up at the Metro food distribution center. They were basically stopping delivery trucks from getting in and out of the distribution center and getting food to the stores. And Metro filed to try and get an interlocutory injunction to stop the picketing. And they were successful in that case. And in that case, the irreparable harm that Metro pointed to was the fact that there were a lot of perishable food goods involved. So that if the trucks couldn't get out in a timely manner and to the stores, that all of this food would go to waste, right? And the court said, yeah, that's irreparable harm. You can't fix the loss of millions of pounds of destroyed food later by simply ordering the union and the picketers to pay money. So we're looking at that sort of thing. So would the university suffer irreparable harm if people are delayed while getting in and out of the university? Yeah, it's less clear, isn't it? Right. Well, one argument against the position that the university would suffer irreparable harm is that everyone can still get into the university. They just need to arrive earlier. Right? Like the picketers are not stopping people from getting into the campus. They are slowing them down, right? And there, of course, nowadays there's also a TTC option at York, right? People can take the subway in and not drive at all. So it's certainly not obvious that a university could be able to meet the irreparable harm part of the RJR McDonald test simply because picketers are slowing down access to the university. So they would, maybe argue other points, right? But that's the university would have to show irreparable harm if the injunction is not granted. Okay. And then the third part of the RJR McDonald test is known as the balance of harm. Okay. And at this point, the courts ask, considering all of the facts, which party will suffer more as a result of the injunction either not being granted or being granted, right? Is the harm to the picketers of not being able to picket in the way that they are trying to picket greater than the harm to the employer if the picketing is not restrained, okay? And that's a balancing test. I would say it's also uncertain how a court would answer this question in the case of a picket line at a university. On the one hand, courts have recognized that freedom of expression requires respect for the right of picketers to delay access to the workplace for a little while and inform people of what's going on, and even if this causes inconvenience. And a complete ban on picketers stopping cars entering the university would significantly weaken the impact of picketing. And as I said, at York, there is the option of TTCing into the campus. So my guess is that the university could have trouble winning a balance of harm argument here in these circumstances, but it would depend on the facts and what's happening on the ground and what the situation is, okay? All right, so where are we then? Well, CUPE picketers are likely to set up picketing stations around the campus. They are likely to stop cars as they enter the campus and hold them up there for a few minutes. Okay, and technically blocking a roadway is a nuisance. It's a tort of nuisance. You can't block someone from entering a property that they have a right to enter. Okay. However, just because picketers may be committing a nuisance, it doesn't mean that the employer, or York in this case, can just run to court getting an order to stop the picketing. The law balances the rights of picketers against other interests. Okay, we've seen here that the employer has to call the police, and the police have to announce that they are not going to intervene, and then the employer needs to file a lawsuit alleging a tort is occurring, and then they need to file an application for an interlocutory injunction to stop the picketing. But we've seen that the test for obtaining an interlocutory injunction creates some hurdles for the employer. They need to show not only that the picketers are probably committing a tort, but also that unless the lawful picketing is stopped, the university or some other party will suffer irreparable harm that can't be compensated simply by a money order later on. And then on the whole, they also need to persuade courts that the harm to the employer of not granting the interlocutory injunction is greater than the harm to the picketers if the picketing is restrained in the way that the employer is asking. Okay. However, even that's not the end of the story, and this is the final point. Even if the employer, or in our case York University, can establish all of these points, and the court is prepared to grant an injunction stopping the picketing, or at least stopping the picketers from committing a nuisance, say, right? Even if the employer can satisfy the Courts of Justice Act and the test for an interlocutory injunction, the order that they will receive from the court is still going to be very limited, okay? It probably won't stop the picketers from stopping cars, okay? Courts usually grant picketers in a labor dispute a limited period of time to stop cars and speak to them about the strike. Okay, look at the order here. I'll put it up on the screen. Look at the order from the Metro case. Remember, I told you that the Metro filed for an interlocutory injunction against picketers and won, right? Well, what did they win? Well, at the end of the day, the court ordered an injunction, but it still permitted the picketers to stop cars for 5 minutes. Okay, so it's not that the court said, from now on, the picketers are not allowed to block any roadway, right? You might think that would be the order, given that blocking a roadway is a nuisance, right? So in other words, the court's saying, well, the picketers are probably committing a tort, but we're going to let them keep committing a tort, but we're just going to restrain it. We're going to control it, right? And so the court says the picketers can stop cars, but only for 5 minutes, okay? And they set up a protocol. And that's probably what would happen in a case at York, right? Now, York is probably not legally able to get an order that would stop CUPE from stopping cars around campus, okay? So when you consider all of this and the cost involved and the effort involved in getting an injunction, and the fact that even if you get the injunction, it's going to be limited in what it does in terms of restricting the picketing, lots of employers don't even bother trying to get an interlocutory injunction, so long as the picketing is peaceful and so long as cars are eventually getting in, okay? It's also worth noting, of course, that asking a court for an injunction to restrain picketing is going to piss off the union and the picketers even more than they're already angry. And so that reality also weighs into the employer's decision about whether it's a worthwhile exercise to go after an interlocutory injunction. Okay? So with all of this in mind, what often happens in practice is the unions and the employers enter into something that is often called a strike protocol, where they agree to certain rules of picketing, right? And often there's a police liaison. So this is someone who is assigned by the police department to be the go-to person on dealing with any issues that might arise, and that person tries to mediate disputes, right? So there's a whole process that's often set up that is outside of litigation to try and keep order to the chaos of a strike and picketing. Okay, so for all of those reasons, barring any sort of criminal activity on the picket lines at York, which we have not historically had, I would be surprised if York does go after an injunction in this case. However, we'll have to wait and see what happens, right? We'll have to see how this plays out. You know, the longer that the strike goes on, the more potential for issues to arise. Okay, so that's my picketing law primer. I hope it was helpful. And let's keep an eye on this situation. All right. Again, I'm David Doorey. I'm at the York University. You can find me on Twitter. I refuse to call it X, at The Law of Work. And there's also a blog that you might want to check out called lawofwork.ca. Okay, that's it. Take care.